So I'm going to change the order slightly for 1 second here, and I want to do something that I have neglected to do earlier today, but means a great deal to me. If you look on your program, you will see that this event is funded in part by a contribution from Janet Dewart Bell. And it was a very generous contribution. It means a lot to the Houston Institute to have this support. You'll see in there that it's in memory of her husband, Derek Bell, who is also a very important figure here at the law school. But, excuse me, Janet is with us today, and it means a lot to me that she's here and to be able to acknowledge her directly and thank her for her support. And I don't know if she might say a couple of words for us, please.
I am so humbled and honored to be associated in any way with this program. My late husband, Derek Bell, would be so honored as well. And I want to thank the Houston Institute, particularly Charles Ogletree, Derek's former student, wonderful David Harris, and Rob Smith, for all that they do to really bring social justice to all of us. And the last thing I will say is that, to me, indigent defense is really the flashpoint in human rights struggle. And there really is no greater cause for us to be associated with. And that the only thing I would say about this program is that it's incumbent upon all of us to, as Steve has mentioned, to tell the story in different forums so that we have other people who join in with this magnificent cause. So David, I thank you very much for the acknowledgement. You didn't have to do it. I appreciate it. And I pledge to support the Institute as much as I can in the future. It's really my honor.
So Marc Bookman's up next. He's threatened my life if I go on too long about him, but he spent 27 years at the Defender Association of Philadelphia in their homicide crimes unit. He now is the founder and director of the Atlantic Center for Capital Representation. They do capital trial consulting throughout Pennsylvania and Delaware. They're responsible for statewide training and programming. He looks very angry, so I'm just going to let you come right on up.
Thank you for having me. Is this mic work? I was having trouble hearing Steve Bright. I wasn't sure if it was working. Everyone that does what I do for a living knows that the worst possible slot you can have at a conference is speaking after Steve Bright. So I have to live with that. I come to you from a liberal, democratic, northeastern city, Philadelphia, home of the Philadelphia lawyer. And yet, Philadelphia is an incredible outlier when it comes to capital defense. And that's what I'm going to talk about now. I don't know, most of you do not remember the great baseball player Curt Flood, who challenged what he called the chattel rule of Major League Baseball, that they were treating him like property. And he got traded to Philadelphia. He wasn't happy about it. He described Philadelphia as the northernmost southern city. And I think what you hear about the way we deal with capital defense, you're probably not going to disagree. Philadelphia is one of the top 5 cities in death sentences over the last 30 years or so, and the top city, the number 1 city in reversals of those death sentences. And I want to try and go on a little bit and tell you why. I'm going to refer to the Rand Corporation, who Steve was not happy about their study of something obvious, but they also did a study of something a little less than obvious that I'm going to get to in a minute. So the question is, why is Philadelphia producing all of these death sentences, and why are they all being reversed? And there is a simple answer for this, and I came in the middle of this, so I did hear the discussion of resources, and that resources maybe isn't necessarily the answer. For some issues, it may not necessarily be the answer, but for this one, it was. The reason that all these cases were being reversed was a lack of resources. So I want to just take a minute to talk to you about the scheme that Philadelphia had to handle these. And it was, in fact, a scheme. It was practically a Ponzi scheme. They would pay court-appointed lawyers $2,000 to prepare a capital case. Now, there are lawyers in this office, in this room, or lawyers to be in this room that are going to make that money relatively soon in 4 hours of work. But they're paying $2,000 to prepare a capital case, and they don't want any messing around. In the appointment for the $2,000, it said that if you ask for a continuance, you do not get reimbursed. I mean, you're talking about a belt that's moving these cases along, like Lucy and Desi eating the chocolates off the conveyor belt. That's what this was. So they're offering $2,000 to prepare the capital case, and then you get $400 a day to go to trial. So it's like they say in All the President's Men, follow the money. And what the money told us, I think, was that lawyers were going to trial, not because the case merited going to trial. Now, we're talking about plea mills and so forth. Capital defense is a little bit different. Capital defense oftentimes the best resolution, not always, but oftentimes the best resolution is some sort of a negotiation. Whether it is or not, what we know for certain is that you don't go to trial to make up your fee on the per diem. And that's what was happening. They were offering $2,000 to prepare a case, $400 per day. So lawyers were thinking, they can do the math. I can take a 1-week trial and double my money. It's not much, but these lawyers aren't much. So for them, doubling the money is worthwhile. So what we were seeing was case after case going to trial, because you can't resolve a case for $2,000. It takes hundreds of hours of investigation and motion practice and knowing your client and meeting him and understanding him before you can even start to discuss any sort of non-trial disposition. Well, that wasn't happening in Philadelphia at all. So case after case was going to capital trials. And of course, there was a predictable result in many, many death sentences. So for 30 years, no one in Philadelphia objected to this fee situation, $2,000, which is by a factor of 50 lower than every other equal jurisdiction in the country, I would say. So no one was objecting for 30 years. And of course, the cases were death sentences and then reversals and death sentences and then reversals. And I'm not telling you that the lawyers in Philadelphia stunk. Although I am telling you that the court-appointed lawyers in Philadelphia stunk. There were plenty of good lawyers. They were all in the institutions. They were all in the Defender Association of Philadelphia, not the Homicide Crimes Unit, the Homicide Defense Unit, Rob. We're not endorsing the crimes. So there were plenty of good lawyers in the Homicide trial unit, and many, many great lawyers in the capital habeas unit, also a part of the Defender Association. But the court-appointed lawyers were dropping the ball for 30 years. Finally, we started to litigate the fees because it was clear that the resources given, and there had been one prior resource challenge. It wasn't for the lawyer fees. It was for the expert fees. And so lawyers came in front of this judge, and they said, we're not getting enough expert fees. And the judge's response, which was clearly right, was, nobody's asking me. I'm prepared to give out some resources. These lawyers aren't even filing the motions to get the resources. So that challenge went, unresolved. The next challenge was ours, and we were challenging the fees paid to the lawyers under the theory that you get what you pay for, basically, which is nothing. The lawyers they couldn't make a living actually representing the client and preparing for a capital trial, so they had to make it up by the daily per diem. So we challenged it, and one of the things we got support from was this RAND Corporation study. And the RAND Corporation studied Philadelphia. We were kind of an incubator for a really interesting test, I would say, which was that the Defender Association, which took these cases seriously, I'll tell you, we put 2 lawyers on every case. a mitigation specialist to do a penalty investigation, and an investigator. So we had the ground floor of what the ABA guidelines require. And then we built a team from that. But every case had 2 lawyers, a mitigation investigator, and a regular fact investigator. And so the Defender Association got every 5th case randomly. And so the RAND Corporation decided, well, we'll study the results. 4 out of the 5 are going to court-appointed lawyers, and then the 5th one goes to the Defender Association. And so what they found from 1994 to 2005 was that the defender clients were acquitted 19% more often than the court-appointed lawyers. Defender clients were 62% less likely to be convicted of first-degree murder. And overall, the defender clients had a 24% lower sentencing rate than court-appointed lawyers. And here's the kicker: when we want to take this, all these speeches and go out and try to persuade somebody, here's the kicker, which is that the excessive incarceration costs caused by the terrible lawyering and the underfunding of the court-appointed lawyers cost the taxpayers more than $200 million in excess incarceration alone. Forget the appeals time, forget death row, forget all the other charges. Just the incarceration rates alone, it was $200 million. So when we talk to our legislators and our court administrators and so forth, we have to remind them that being penny wise and pound foolish is not a solution to this problem. 20 years from now in Philadelphia, we're going to see the same injustices that we see every week in Philly. Every week there's a new reversed case. I'm going to talk to you about that in a minute. So we challenged the fee schedule. And I should say one other thing, which was in the 20 years now, the Defender Association handling these cases, the Defender Association hasn't taken a single death verdict. The private bar has taken well over 80. So again, you do the math. The defender should have taken about 20 of them, but they didn't take any. So what that tells you is not that the defender lawyers are fantastic lawyers. It simply says that a well-trained, competent group of lawyers who have appropriate resources can essentially end the death penalty. And I'll talk about institutions in just a minute. So we challenged the fee schedule. And I want to tell you how that went. We filed 2 petitions in Philadelphia, and the administrative judge denied both of them. It was a little bit of a hostile engagement that we were dealing with. The second time our motion was denied, it was because we had not properly numbered the paragraphs on our petition. This was the level that Philadelphia was stooping to so as not to pay reasonable fees. The Supreme Court accepted jurisdiction for this challenge, and so here's the evidence that we presented. First of all, we brought out the last 25 capital reversals in Philadelphia, and you heard me correctly, the last 25. There have been many, many capital cases in Philadelphia, almost all of them reversed. We looked at the last 25 reversals, and it turned out that the district attorney had agreed to 60% of them. 15 of the 25, they didn't even contest. They said the job was so bad, we're going to concede either a new trial or a new sentencing. And this is a hostile prosecutor. They couldn't even bring themselves to challenge 15 of the 25. They lost the other 10 after a challenge. And then we brought out what we call the quarter sessions files, the official court files of the last 25 capital prosecutions. And we found that very consistent among the 25. Virtually no visits by the court-appointed lawyers to see their clients. No jury questionnaires asking the judges to do a reasonable voir dire, and no motions at all. We're talking about, Nancy Gertner was talking about an arson case. There had been no motions filed. These are capital trials, death penalty trials with no motions filed. And I say no motions filed, I don't actually mean that. There was consistently one motion in almost all of the 25. It was handwritten by the client asking for another lawyer. We saw that in 18 of the 25 cases, a handwritten motion asking for another lawyer. So while this litigation was going on and the city was being a little bit embarrassed, a homicide appointment committee was formed. This was formed of defense attorneys, judges, and a couple of prosecutors. And they were screening the lawyers to see who could do a qualified job. Where were the qualified capital lawyers? Remember that there's very little money being paid. Most of the good lawyers don't want any parts of trying to prepare a capital case for $2,000. It can't be done. So the homicide appointment system got together, and they started to figure out how many lawyers were qualified. They came up with very few. Very few of the applicants were actually qualified to handle these cases. So the administrative judge was concerned about this. Rather than looking for more qualified judges, more qualified lawyers, he instead disbanded the committee. That was their solution. So the committee all got fired, and they went back to the same hacks that were handling these cases before. There was a change. Because even the hacks didn't want to do it for $2,000 anymore. So they changed it, and they made the fees $10,000 to prepare. This is the flat fee that Steve Bright rightly condemned recently. Flat fees don't work for any number of reasons. The lawyers have false motivations. And I'll tell you exactly how that has played out in Philadelphia as well. So they raise it to $10,000, and then they're paying the $400 per diem, but only after the first week. The first week, the lawyers have to work for free. I said I thought that was a good idea if the prosecutors and the judges also worked for free, but I wasn't taking up on that. So still, it's a flat fee of $10,000, $7,500 for the second lawyer, and then this $400 after the first week of trial. So what we're seeing now in Philadelphia is exactly the opposite. Rather than every case going to trial, now the lawyers can just grab a quick 10 grand and plead the clients out. So now very few cases go to trial. So, there's a middle ground, right? You pay a reasonable hourly rate, and the cases that should be resolved by plea get resolved by plea. The cases that need to go to trial properly. But that's not the way Philadelphia is seeing things right now. So today, as we stand here, a court-appointed lawyer gets more money to handle a capital case in Philadelphia, Mississippi, than in Philadelphia, Pennsylvania, and that's just a fact. So when we follow the money, we see that court-appointed lawyers are only human. Some of them are a little less than human, actually. And so, if we follow the fee schedule, we understand the motivations of the lawyers and how the injustice, the litigation was never about making more money for lawyers. It's always about fairness to the clients. And if a client is not meeting his lawyer or going to trial when they shouldn't be, that's no better than a client that gets persuaded to plead guilty when he shouldn't plead guilty. Either way, it's a fiscal challenge and a resource issue for our office. Now, I haven't been speaking all that long, but I'm almost done. Things are not getting that much better in Philadelphia. We now are they're trying to put together a conflict office for the public defender. They're not willing to give the public defender more of these capital cases, although I think the public defender should be handling the great majority of them. They're not willing to pay because the public defenders are a little more expensive than the private lawyers. Again, this is a penny wise, pound foolish situation, right? The lawyers get paid a little more up front, but do a great job and save the taxpayers all this money. Instead, they're trying to be, pound foolish, paying a little bit and then worrying about it later down the road, not worrying about the clients. I wrote an essay recently about an injustice that happened in Philadelphia. It was two guys that had falsely confessed to a crime. They were both in prison for 20 years. And then my client came along, and as luck would have it, he actually had committed the crime for which these two guys had spent 20 years in jail, and my client had confessed to this crime and a number of other crimes. He was clearly guilty. And the judge brought the two clients who were innocent in front of him after 20 years, and he congratulated the district attorney for a phenomenal investigation. They had done nothing. And then he said the immortal words, we're grateful to the prosecutor for avoiding what might have been an injustice. You think 20 years these guys spent in jail. The judge thought it might have been an injustice. Thank God for the prosecutors who were able to avoid this potential injustice. So we have to keep our eye on the ball. And the ball is never about the lawyers. It's always about the clients, and that's where the injustice comes from. And when we talk about resources, we're not talking about resources for us. We're talking about fair results for people, indigent people, accused of crime. I'll end with an unfortunate situation that's now going on in Philadelphia. To form this conflict office, the city has proposed a brutally underfunded for-profit agency. So it's the worst of both worlds. They're paying virtually nothing to handle these cases, which is why only one organization, one lawyer stepped up to do it. They're paying practically nothing, and then it's for-profit. So the lawyers handling these cases are going to be forced to decide between, do we hire this expert? Do we do more mitigation or more investigation or more whatever? Or do we make a profit for ourselves? It's an unfair situation. Now, like I said, I don't think the words for-profit and indigent defense should be in the same sentence. They don't really make sense together, but that's what Philadelphia is doing now. It's honestly a city that's trying to push itself into the 20th century in terms of criminal justice. And I'm not making a mistake there. I know it's the 21st century. I'm aware of that. Philadelphia is trying to push itself into the 20th century. We're in the 19th century right now. So I want to end with what Steve was talking about, which is what can people do about this? And of course, Steve stole the last part of my presentation, but it's predictable because we all know what we can do, right? We do have to shine a light on we have to write op-eds, we have to talk to legislators, we have to get appropriate funding. We have to make sure that quality lawyers are handling these cases and not lawyers that are after the $400 per diem. So we know what we have to do. The people that become lawyers out of this room, you guys are the movers and shakers. That's just a fact. I didn't go to Harvard. I went to a second-tier law school. No, I didn't. I went to a good law school. North Carolina. I went to Chapel Hill. If they tape this in here, they'll kill me. But I didn't go to Harvard. So you guys are really the ones that are going to shape policy. You guys are the ones that are going to be in the legislature. You're the ones that are going to become judges. If you make that decision, these are changes that can be made. Clarence Darrow said well more than 100 years ago that we're going to know that things are just in our communities when we spend just as much on the defense as we do on the prosecution. We're nowhere near that now. It's like Steve said. Thank God I'm way younger than Steve. So maybe I will live to see it. I don't know. But this is a dogfight, and we have to make sure that we seek fairness. I see. Someone said that Gideon was the high point of our Supreme Court jurisprudence. I see us as the stock market. You hit this high point, but we're going down like this, and we can't go down like this. We can easily come back up through fair resources and fair quality assessments of lawyers that are taking this work seriously. So thank you for having me here. Really a pleasure.
So I teach at the University of North Carolina, and I'm going to go back and tell Jack Boger, our dean, that you'll be doubling your alumni contribution and taking 2 interns every summer from now on. So thank you.